and look forward to answering questions as we go throughout the program. Feel free to chat, and I'm looking forward to everybody's comments. So one more minute, we'll be ready to begin. Okay.
I gotta go on mute here.
Okay. Okay, it's time to start our program, How to Get Paid Even When Your Mechanic Lien Rights Expire. So I'm looking forward to having a discussion. My name's Hal Emelfarb. I am the General Counsel for National Lien and Bond. National Lien and Bond was formed in 1986. And, from then till now, you'll see our work product of what we've done in summary at the end of the program for a lot of companies like yours, and looking forward to providing you with the information to help you and your organization be in a position to collect your money on every project. That's our goal, and I know that's your goal. So I'm looking forward to discussing this with you, and basically making our presentation to assist you understand the legal rights that you're going to need and keep available for you on your project. One of the things we're going to do today, I thought you'd be interested, is I'm going to tell you a story of the couple of our clients in general. Not going to be necessarily naming names except for one, because it's a public court filing. I think it'd be of interest. Our firm is representing a client, and I kind of was inspired by what he did and what we were able to do to help him so far in pursuing his rights to collect his money, even though he did not file a lien, or in this case, he was actually working on a federal project in Afghanistan, and he happens to be an Afghan subcontractor working for an American general contractor, and that job was not bonded. So in this situation, our client is a subcontractor, and the client was working for a company who ended up filing bankruptcy. Now, on every federal project, you may be aware of this, for construction over a certain dollar amount of about 75 to 100,000 is a payment bond called a Miller Act payment bond. And you cannot lien a federal job, but you can file a claim against the bond. Because the project was done in a Air Force base in a war zone, they were unable to get a surety bond, and that was waived. So you'll hear, I'm going to use his case as an example for you to tell his story of how we were able to get him in the position to get paid, even though his bond rights and there were no lien rights that existed expired. And you'll see the importance of what he did on his own before we ever met him. And I'm hoping to inspire each and every one of you to also go ahead and be in a position where you're able to understand what he did and how I believe it'll help him help you get into that position of protecting yourselves. I think it'll be very exciting to get everybody's feedback when we're at the end of the program. And as I said, if you want to chat throughout, I'll be paying some attention to it and to try to help you. But I'm very appreciative of you coming today in this time of the pandemic, the time of economic turmoil. You'll see that most of us in our legal network, and maybe many of you, have been through these hard economic times before and how to cope with them. I think it's an interesting challenge we have, all of us, because most recessions, construction and real estate is inactive, and in this recession, it's just the opposite. So we are definitely into new challenging times, and we're looking forward to helping you protect yourself in this circumstance. Um, Many of you may not be aware of this, but National Lien and Bond is an organization that's been around since 1986. We started the organization in 1986, before there was an internet, before there was a group of lawyers around the country, and we summarized the lien laws, bond claim laws, and then we developed an inventory of what rights exist in addition to lien and bond, which we're going to talk about today. And the exciting part about this is I kind of near the end of my career, my son's working here, other young lawyers are here, both here in our office in Chicago, where we're located as general counsel. And then we have a lot of attorneys with a lot of experience, men and women, and we have a lot of younger people that are coming and joining our program. So if any of you know young lawyers or experienced lawyers like myself that are looking to affiliate with National Lien and Bond, we're always looking for recommendations for local counsel. So our promise to you today is we're going to show you how you're going to recover on your biggest asset, that's your job receivable, and how you should protect yourself in today's environment. So we can't predict exactly what's going to be happening, but I can assure you that if you protect yourself, you're going to be in better shape, because smart business people are definitely tightening up your secured transactions and credit practices in legal compliance. Now, economic instability, as I mentioned a few minutes ago, is not new to most of us in construction. We're used to seeing that in the recessions. We're used to seeing that every day on jobs. I would say that the legal risk and the economic instability or credit risk that you're experiencing is something that exists even in normal times. So all of us are used to dealing with economic instability. Seasoned construction executives have managed multiple recessions and major economic downturns. So we do have a experience. Now, economic instability for many of you is not new. Let's look at what happened in 1791 when the first Mechanic Lien Act passed. In 1791, this was the end of the first Congress of the United States, and in this time, they were creating the nation's capital. And in doing that, they created an act in the 10 by 10 square mile area around Washington, which was actually the states of Maryland and Virginia, which each gave 5 square miles. And they created a Mechanic Lien Act. Why did they need a Mechanic Lien Act? To encourage master builders to undertake the building and finishing holes within the city by securing them with a just and effectual remedy for their advancements and earnings. That all sums due on written contracts for the building of any house in the city or the brickwork or carpenters undertaken by persons for the whole house that will be built shall have a lien on the house and on the ground that it's erected, as well as for the materials found by him under a written contract acknowledged before a commissioner or justice of the peace. I mean, here we are in 2020, and look what they were doing in 1791. So today we're going to go through 3 things: how to secure your receivables by reviewing your contract, planning your legal compliance on a job-by-job basis, and monitoring and enforcing your contract rights and remedies. So project facts that you create through what you do every day and all your actions in a project or in a transaction help get you paid. And what we're going to be looking at is what amounts you can claim, how to make your claim compelling, what's the timetable, the strategies, and what do I need to do, what do you need to do to negotiate and get in a position to secure yourself and negotiate your claim to protect your interest. So I told you I'd be telling you a story, and the story starts out by one day I received a phone call from Afghanistan. I didn't realize, I kind of thought it wasn't even a real call when it came up. It was very unusual. My client in this published case in the United States Court of Federal Claims is this company here, Fox Logistics and Construction, who is a subcontractor who did 90% of the government work. Now, how does a subcontractor file a lawsuit against the United States when it doesn't have a contract? Well, that's the same facts that you'd have to create for yourself, which this subcontractor did himself, which I'll explain. So in this situation, factually, our sub went to work for a general who actually told the United States in 2013, on New Year's Eve, the general said to the US, the owner of the property, of the Air Force Base contract, I have no more money and I have no more money to pay. Yes, I used the subcontractor's money on other projects. When we did that and we reviewed what happened, this is right out of the court opinion. Judge Wheeler recognized that we claimed, as his lawyer, the subcontractor, that our client was a third-party beneficiary of a contract between Lakeshore and the Department of the Air Force. And we claimed that we had implied in fact contract and that the Air Force breached its duty by not paying us, by not acting in good faith and fair dealing. Well, you can imagine the Air Force and the government wasn't happy about our lawsuit, and they moved to dismiss it. And we'll talk in a few minutes as we proceed a little farther along about what happened next. So what all of us do in a position that I'm in or you're in, is we look at the internal credit and legal compliance risk on every job. And how we do that typically is we have a contract checklist, a job data form, and we perfect our notice and claims. We also need to pay attention to what is going on and strategize to put us into a better position. Today, particularly in your contracts, I mean, when COVID hit right in the beginning, I never really used the force majeure provision clause in 40 years of practice. All of a sudden, force majeure really meant something. And these were the events that were for sure unforeseeable, outside the control of the parties, and a result of circumstances other than your own negligence. Well, somehow we got lucky because construction ended up being essential activities in most states. In some states, it wasn't. But that's a provision we've never used before. So what are the top 10 contract provisions you should be aware of? Because if you're going to collect your money, you have to have a good contract. And you'll see why and how that fits into your negotiation. What is your scope of work? What is your design responsibility? What is the payment issues, changes and modifications that come up with change orders, contract termination or defaults, flow-through clauses? Now, we're in a situation right now where one of our clients is installing windows on the East Coast project, a private job. And it's a hotel, casino kind of facility. In there, our client put in a provision, which I thought was brilliant. He said that I, the subcontractor, agree that I have to have the same rights that you, the general contractor, have against the owner, because you're telling me as general contractor, any rights the owner has against you, you're imposing upon me. So he actually reversed it, our client, and he said, I am entitled to the same rights as you are entitled against the owner. Why was that important? Because what ended up happening was that our client, in his general contract, was responsible for consequential damages. But the general contractor, in his contract with the owner, actually took that clause and limited it and said, we are not responsible for any consequential damages. So because there was a flow-through clause, this way, not from the GC against us that was detrimental, but beneficially from us as a subcontractor, through the general contractor to the owner, the subcontractor has the same rights against the GC that the GC has against the owner. And that was just a really fortuitous circumstance when we as the lawyer came in, because everyone's claiming now that the hotel and the casino isn't making money. So it's important for you to know your clauses, and this seminar is not about contract clauses per se, but to show you what clauses really stand out. Dispute resolution, which basically is mediation and arbitration, that's an important clause. I would say today it's probably one of the more important ones. You don't want to be involved in litigation if you can avoid it. You don't even really want to be in arbitration. You do want to mediate, but you've got to be able to mediate with really good mediators. And then if you can't finish the mediation successfully, which is not usually the case, but sometimes happens, then you've got to decide, am I better off to be in court or arbitration? So you've got to be careful on those clauses. Project scheduling seems to be a problem these days. We just had a client last week call us up. He hasn't been paid in 3 months, and the general contractor, also is partially a developer, told my client he's not getting paid at all because he delayed the job. I went ahead and looked at the apartment complex, and we had 5 buildings, and the first 3 buildings aren't even filled up with tenants. So I told the general contractor and who owns part of the development, I said, how can you claim we're delaying the job and there's liquidated damages or problems when in fact the apartment buildings 1, 2, and 3 are all done on time, and 4 and 5, which aren't done in time, yeah, there's a little bit of a problem, but a lot of the units are occupiable, and somehow, I don't know if many of you are experiencing this, but project schedule and delays seems to be the way the general contractors make up for, their own inefficiencies and problems. Then we have scheduling and indemnity and hold harmless. Now, one of the biggest risks that I've seen recently is indemnity and hold harmless agreements are very, very important. And who gets an additional insurance certificate and who gives one and how all this lays out is something that each one of you, particularly the subcontractor or GCs, are going to be involved in whenever there's a construction defect case or a case in which insurance is applicable. And when you're insured with indemnity or hold harmless, it's important because you're agreeing to indemnify and therefore defend usually the general contractor. And if you're doing that and you provide an additional insurance certificate to him, then your insurance company is the one that's going to stand in and provide for the payment of the cost of defense. So these are really important. These are the top 10 provisions that I've looked at recently that I thought you would be interested in seeing. Now, on payment, a pay if paid and pay when paid is an important area. If you're going to get paid in construction, you need to know that you have a pay when paid clause versus a pay if paid clause. Because if you're going to be paid within 7 days of when the GC gets paid, then that is only for a reasonable amount of time. It can't go unlimited. But if it says, I'm not going to pay you unless I get paid, and so on, and it details the condition of proceeding, as you'll see in a second, courts are actually upholding these laws against subcontractors in some situations. And I'll also show you in a second how we can get around that as well. So a pay if paid is a clause proceeding that requires payment from the owner before the contractor has a duty to pay you. The difference is whether the contractor has a legal duty to pay if the contractor never receives money from payment from the owner. So what happens is a typical pay when paid clause is not pay if paid, but pay when paid, is when the contractor shall pay the sub each progress payment no later than 7 working days after the contractor receives payment from the owner. So that clause basically delays payment. When we have a situation here where judges are interpreting clauses, the clauses that provide condition proceedings will say, like, upon the owner's acceptance of the work and payment to the contractor for the subcontractor's work are conditions precedent for payment to the subcontractor. Well, the court considered that, and they upheld that there's no liability on behalf of a surety because the GC never got paid by the owner. So these kind of provisions that you put into the contract, pay if paid or pay when paid, are very important. And these provisions end up making a difference as to whether you're going to get paid. So it's really got nothing to do with a lien. But a lot of cases in Illinois, New York, Indiana, Ohio, and about 6 other states have said, well, even if you signed the pay if paid clause, like for example, in this West Fair Electric case versus Aetna in New York in 1995, the court said subs must be able to take advantage of their lien laws, and therefore ruled that a pay if paid provision is unenforceable as a matter of public policy. And what does that mean? It means that if you're in a pay if paid scenario and you have your lien rights, then you would basically be entitled by law to file your lien. So therefore, you have no rights under your contract to force the GC, but you can force the owner to pay because you're perfecting your lien rights. So you can see the distinction that the courts will allow you to proceed against the owner, even if you have a pay if paid clause when you sign up a contract with a GC. So you've got to be careful on how your contracts come out and what provisions they apply and how this helps you. So one of the things that I really recommend you look at is when you have clauses, you're trying to get a job, particularly now where the work is going to probably slow down a little bit, so you're going to probably take more risk. So they include liquidated damage clauses or a waiver of consequential damage clauses. Well, you could ask for that. You could say, I'm a subcontractor and I'm a supplier, and I'm not going to be responsible for any delay damages or these soft consequential damages. I don't want to be responsible. They go, well, you want the job? So you go, yes. Well, you're going to have to take on the responsibility of this. Well, if you have to do it, which I recommend that you strike and don't do, but if you have to do it, limit them to a certain percentage of the dollar amount. Because if you're going to be liable for liquidated damages and you're going to be liable for consequential damages, they actually will exceed the balance of your contract by the time the battle the battle starts. What happens typically is these clauses don't really get imposed to near the end of the project. So let me give you an example of a situation that we find ourselves in quite often. A client is out there working as a subcontractor, or he's making product and selling it as a manufacturer, and he gets paid down 40%, 60% of his contract. That he's owed quite a bit of money, 20, 30, 40%, and you could charge back charges. Well, if you don't cap your exposure with a small amount of money, no more than 5% of my contract, which, by the way, the GCs for some reason, like you, they don't mind when you do that, but they won't let you go ahead and delete the entire clause. So they let you limit your liability in most situations because they see that you're in for good faith in case something does come in. You'll share in some of the exposure because the general contractor is all about that. He has to measure and manage his exposure. And he does that by basically imposing his will over you during the project. So once you're done reviewing your contract, then the second thing would be, even though this is a seminar about how to get paid when you don't have a lien, you do need to know your statutory lien rights a little bit. So the best part about a lien, and it kind of really gets into what happened in the story that I'm telling you about my subcontractor client in Afghanistan, about how he got involved in suing the owner, in this case the United States government and the Department of Justice, even though he didn't have privity with them. Well, the other way of doing it, other than the equitable remedies, which we'll talk about, and how you can collect money without a lien, is the lien allows you to do the same thing as we read in the particular first lien act, and all lien acts since then basically adopt the same terminology. You get to go ahead, if you're not in privity with the owner, and have a right to a lien if you don't get paid. So what that means to you is you can protect yourself by your lien rights, or I'll explain another way you can protect yourself, because what you're really doing is extending credit not only to your customer but to the project. So I think one of the most important things that really exists for each and every one of you is really to understand this key feature. This key feature is that when you extend credit in construction, you extend credit multiple parties and multiple times. So if you're a supplier, you're extending credit to your client. Let's use an example, a supplier of electrical products or light fixtures. They would typically be selling their products to a subcontractor, and then the subcontractor is selling the products to a GC, and the GC selling the products to the owner. So effectively, you as a supplier have effectively, this is how I've looked at it, and I've been successful when I've looked at it this way. Most attorneys don't think of it like this because they go, who's your customer? That's who your rights are with. I say, who's your customer? Who's their customer? Who's their customer? Where's the money? Because what we're really trying to do here is find the money and get paid. And our customer doesn't have it. So I don't really want to spend time with our customer when he's not getting paid or he's caused the problem. So you have to identify that. So when you do that, you extend credit to your customer, to the sub, to the GC, and to the owner. And the mechanic lien law allows you to do that. Joint check laws and joint check practices, which many of you probably have engaged in, do that as well. So what happens when you get a joint check with a general contractor who agrees to pay a sub and a supplier by joint check? Well, if that joint check is signed before you ship, then you're going to get paid. Even if the subcontractor goes bankrupt and you don't have a lien, you're going to get paid if you have a joint check agreement, if you're a sub to a supplier to a sub and a GC, and the GC agrees to pay you by joint check. Now, if the owner agrees to pay you as a sub, which sometimes you do because the GC is defaulting, and they want the GC to kind of like work it out, is the owner gives you an agreement to pay you or is paid you by joint check. But when this works, and this gets back to your rights against a party other than your customer of how you get paid, when this works, it works because you've got that agreement before you did the work or before you supplied the material. You can't do it after the fact. If you do it after the fact, there's no reliance, there's no consideration, there's no promissory estoppel. But if you do the work beforehand, and before you get the joint check agreement beforehand, it's signed and approved by everybody, then you get a situation where you're able then to get paid because you rely on it. The first case was done in Pennsylvania when I started in the 1970s and 80s, called the Dynaforce case. And the Dynaforce case basically provided a situation where the clients got paid. And in doing that, the clients got paid where the subcontractor filed bankruptcy. And even though they filed bankruptcy, we got our client paid. In other cases, relying on Dynaforce versus Tempway case, where it said, if you obtain an agreement for somebody to pay you jointly, or they pay you jointly and tell you to continue working, then you're going to go ahead and get paid on that from not the person who's your customer, by somebody else. So it's very helpful in that regard. Okay, so you're extending lien, I call it lien credit. I don't know, I came up with this concept, lien credit, to a project. You know, all these fancy people and hedge funds and stuff, when they go, what is this you're talking about? What is a lien? Well, lien credit is how I extend credit to a project, because I make sure my mechanic lien provides security to assure me that I'm getting paid and get a legal hold on a property, just like a mortgage. And I think it's very important. Now, the other way to do this is add into your contract, because sometimes I've been adding a clause into people's contracts lately for two reasons. One, so they have a claim to go like a lien credit. And here's what we basically do. So let's say you're a supplier or even a subcontractor. Under Article 9 of the UCC, it's called secured transactions. Secured transactions provide your receivable with collateral to get paid. So how you do that, I did that recently for a client of mine in the window manufacturing business, or it could be electronics, light fixtures, any supplier of materials, or any subcontractor. I said, you, my customer, in this case, the subcontractor, grant me, the supplier, a security interest in your proceeds for the project for which I'm supplying you. In this case, it was windows, okay? And my client goes, why are we doing that? I said, because under the laws of Arizona, you aren't covered as a supplier to a supplier, which is the situation you're in. So you're going to get your customer now to give you basically a security interest in his rights, which include his mechanic lien rights, and he's going to assign those to you. So if you're not able to get paid and he's not getting paid, you can stand in his shoes and take over his lien rights to get paid. So while you don't have lien rights, the customer ahead of you does. Another way of dealing with this, if you find yourself in a situation where they don't want to do it up front, then you kind of want to ask them to do it when you all get in trouble together and you're not getting paid. Because then you can kind of team up. We'll talk a little bit later about the value of teaming up with your customer to go forward, because sometimes you as a supplier have more bandwidth or business acumen than the subcontractor. Not always. We have very bright people in both cases, suppliers and subcontractors, but teaming up makes you even better because you feel like you can save some money and by sharing the cost, and also, more importantly, not fight with each other, because I often find my clients in a situation nationwide where they want to continue selling their customer. So we take this problem and put it aside, work on how to solve it, and to go forward. So mechanic liens and payment bond claims are the best way to ensure project securitization. I just showed you another way through the Article 9 secure transaction, which is, the difference is this. When you go ahead and basically have a situation where you have legal rights for mechanic lien, you have that because of the statute. So let me explain. Like in Florida, it's a pretty simple one. So Florida, you've got to do a 45-day notice of furnishing from first day delivery. Then you file your lien within 90 days, and you file your lawsuit within a year. Now, I'm not a Florida lawyer, but I've worked and managed a lot of claims throughout the country. I've written software programs about the logic. of how all this works. And I also am familiar with the general 3 steps. If you're not dealing with the owner, you have to give a notice. Everybody has to file a claim. Everybody has to sue. So when you're doing that, you're in a situation where you're protecting yourself and you're protecting your customer in that regard. And I think that's kind of important, basically, that we kind of remember those are the steps. But if you're doing that because it's a statute. It's not a contract. You're automatically granted lien law protection and payment bond protection and other protections, which we're going to talk about in a minute. So the idea here is, as a supplier, and your rights are based on contract or they're based on the statute. So you've got to look at both, because these statutory remedies are becoming more and more familiar. But the reason why I'm asking people, even if they have lien rights, to take a UCC Article 9, I don't know what your experience has been, but my experience recently, and it's been a problem. My experience recently, I'd be curious if anybody else is experiencing this. What I see a trend happening right now is every time we lien a job, the general contractor puts up a $500,000 bond and bonds over it. And now we have to go sue, and he's got our money, and he basically tries to wear us out. So we're pretty tenacious, and we know ways to get around that sometimes. But I really want to design something, just when we talk about lien credit. We were the first ones, I think, to come up with the idea, and many people still don't incorporate it, that you're extending credit multiple times. Well, if you can go ahead and get your customer to give you a promise that he'll give you his proceeds on that job that you supplied to if you're not paid, then even they bond over it, they can't bond over a UCC Article 9 pledge of personal property. They can only bond over the real property, the lien. So why would I want you to look at how to get paid without a lien? Because I'm finding even with liens, we still have a situation where you're in a predicament where they go ahead and bond over, and now you're like, okay, they got your money, but if you follow the advice I'm giving to my clients now, and you put a UCC 1 term in there, you become a secured creditor as a mechanic lien claimant and as a business person under Article 9, which is that your customer granted you a security interest in his right of proceeds that he has against the general contractor and his lien rights as well. So you can then piggyback on top of that, and that gives you a little bit more leverage. Because look, the reality of my practice has been dealing with many, many people who are not getting paid, and litigation is not where I like to go. You'll see that I put myself in litigation if I have to. I have a whole legal staff around the country that we work with, and paralegals every day, and notice service people. But the reality is, even when you litigate, 95 to 97% of all cases settle. So the quicker we can get to that point, the more leverage we have, the better off, as you'll see what our formula is. Okay. Now, if you have a compliance system, like we're talking about, if you implement it correctly, it pays for itself many times over. So in order for you to understand your rights, if you're a national company or a local company, you need to know what state is your project in. Then you need to know if your project is private, public, or federal, because we deal for 40 years in all these areas. And then you have to say, what is my role on the project? If you're a GC, you have different remedies and different no's and deadlines than if you're a sub or supplier. Suppliers to suppliers aren't covered, and you've got to look for ways to cover yourself when your lien rights don't protect you. So I'm finding myself often in one of two situations guiding people on what happens when they have no lien rights, and that is when you're a supplier to supplier, or you lose your lien rights, or you decide you don't want to file that action, or even when they bond over your lien, you have a lien, but it's got security, but that's discharge. So our suggestion to you is to be in a situation where you find yourself not after the fact, when you come to a lawyer like our legal network or myself, and you just say, hey, I got a problem. You should be thinking about this every time you sell a project. And we have a project data sheet in the form and a system that we're developing, and it's getting better every day. And we've been doing it for 40 years manually. They think we're like an internet company. We're not. We're actually a legal network since 1986, and we've suffered through clients' experiences, and we've celebrated mostly with our success with getting them paid, but in understanding how to learn. So when we do that, you're in a better position that you attack your compliance for credit and for your credit and legal compliance actually before you actually start working. Okay. Now, extending credit is unique in construction, and there's many payment mechanisms that are out there. I don't know how many of you, I was actually around when they first started this company because they did this in Chicago. So we were involved with it early on in the early 2000s. But Textura, that's a payment mechanism platform. So I'd be curious to know if you can chat back with me and let me know if any of you have used the Textura platform. I'd be curious about that platform. I'm very familiar with that. And it's got its pluses and minuses, but overall, it gets people paid. Now, how many people control your funds as the money comes out? Well, as everybody knows in construction, you've got a bank, and the bank goes ahead, and the bank will give the funds to the owner after the owner gets a draw from the general contractor, after he gets the payment application from the sub, and the subs get the waivers from the suppliers. So all these parties, all these people are involved in getting their hands on your money and also filing paper in order to get the money out. So what we see is your money is controlled a lot of times by third parties. And if you have no control and no communication through this process, you put yourself more at risk if you don't understand it or have help in order to get it. Because extending credit in construction, I call it lien credit, is very difficult to really effectuate every day. Now, when you're done with protecting yourself, I haven't talked to you about, we have the deadlines online. I'm happy to have this discussion with people individually that need help within one state or all 50 states. But the reality of it is that there's a situation where we have, you have to understand how the credit collection problems works by law and how sometimes it actually works. And we have to find ourselves in that position. So understanding mechanical lien laws, I'll just tell you briefly, the issues that you are are in a position where you'll need to think about and address as you develop more and more information on mechanical liens. And I've been doing this for 40 years, and I can tell you, I learn something new almost every day. So what is lienable? What kind of classes of liens exist? Who should you serve with a lien? How much should it be for? When do courts consider a job complete? What are the elements of a lien claim, which are basically a contract, performance, an amount due, and not being paid? And when is a lawsuit necessary? So, I mean, that's a program in itself, but I just wanted you to see, what was going on. So every state has either legislation by statute or case law that helps you get paid. Mechanical liens help you get paid, but we said this is a program about what happens if I don't have a lien. Then go look for the payment bond claim. That can help you get paid. Payment bond claims are provided on private and public jobs. I'm surprised how many private jobs have payment bonds, and you have to ask for them again up front. Looking for them after the fact isn't the best time. Prompt pay laws are important. Trust fund laws are important. So let me stop here at the trust fund laws for 1 second. There's two stories that I want to kind of like tell you a little bit today. One has been so far, and we haven't finished talking about it, is our subcontractor in Afghanistan, whose contractor basically filed bankruptcy and left him in the middle of the night one night being owed a lot of money, and there was no bond on the job. And we'll talk about where we're at on that project because it's still kind of fluid. Then the other projects that I've seen a lot with recently, in the last couple of years, are on telecom jobs. On telecom jobs, we found a large telecom, they call them turf vendors. These are people like general contractors that are hired by the carriers. They go out and hire subs, electricians, and people to do work on cell tower sites. They go ahead and they work in states, for example, like Colorado. In Colorado, if you are a owner and you pay a GC, the GC pays the sub, and the sub doesn't pay you as a supplier, or the GC doesn't pay you as a sub, or the sub doesn't get paid by the sub. The person that doesn't make payment, who last touched the money, has to realize they have a duty to hold the money in trust and the money has to be held in trust. So if you're a sub and you're hiring a sub in Colorado, and you're from another state, or you're from Colorado, or other states, there's about 15, 20 states that have the same trust fund laws. But Colorado's go very extreme. If you don't pay the person after the owner pays you as the GC, or the sub gets paid by the GC, and they don't pay the supplier, you can't go bankrupt in Colorado and get out of that obligation. You cannot. It's really unusual. So I found myself in a case where an Atlanta GC, or turf vendor as they call them, went out of business. He filed not bankruptcy, but an assignment for benefit of creditors. And our client never got paid by his company. The owner of the company and the person that wrote the checks, I sued them for violating trust fund laws. It turns out in Colorado, our attorney there, his name's David Little, he was able to get into the federal bankruptcy court, federal law, an adoption of the trust fund laws of Colorado that said, if the customer that has the money goes bankrupt, the principal that controlled the funds at the time of the non-payment violated the trust fund laws and created a misdemeanor or a criminal act. And in doing that, the bankruptcy law will not protect him. That's like shocking to me, but as shocking as it was to me, it was more shocking to the general contractor, the turf vendor, when we sued the CEO personally for diverting the funds from where they belong. Because in the construction area, the reason we call this lien credit, the reason we want to go beyond lien credit and try to get into personal property liens on top of that to secure people now, is because you are part of an entire budget where an owner puts in money, a lender puts in money, they pay it out to the GC. None of it really belongs to the GC. 80 or 90% of it belongs to the subs and suppliers. How do they get their hands on your money and allow this to happen? Well, trust funds say they can't. And in Colorado, you can not only go to jail, you could actually be basically a debtor to the person who you stole the money from for the rest of your life, and you can't get out of bankruptcy. So it's kind of important to be able to follow the money trail and be in a position to get yourselves paid. And that's really what this is all about. You know, again, we call this lien credit, but those are trust fund laws. We talked a little bit about the joint check. We talked about Article 9. Now, if you're just suing your customer, if you have a confession of judgment clause, you can literally get a judgment within a matter of, let's say, a week. This is not a bad provision to have in your contracts. If you get it within a week, you can't collect it from the customer, but you can tie them up by enforcing your judgment with assets. So let's say I'm a supplier and a subcontractor signs my credit application and I get a confession of judgment against him. He can move to open it up, but he can't have the judgment vacated. He can have it open. So it still stands for collateral. So you basically, as a supplier, say to your subcontractor or your customer that on my credit app, I have a lot of legal clauses. That's how I do business, and please sign my credit app. They don't even pay attention to it most times. So you go in to get a judgment, which is done without the person even being there, because they've given you permission, like a power of attorney, to confess a judgment against them if you didn't get paid. Then, once you've done that, you can record the judgment, and now that secures you in the county where the person's at, and you can enforce the judgment with a citation or garnishment against money that's owed to them. It may not be, you may not be able to get the final judgment and the final assets, but you put yourself in security and you're able to do that. So we've talked about 3 different kinds of liens: statutory liens, Article 9 liens, which are against personal property of basically not the property, but the contract proceeds for which the people assign to you, that they'll, like a sub would assign to a supplier, and the sub is assigned to supplier. His rights to proceeds that the general contractor owes him. And now we've got a third kind of lien, a confession of judgment. And in this situation, confession of judgment, it gets recorded just like if you had a judgment against you, where you can't sell your property, because it's recorded in the Recorder of Deeds office. And you can go ahead and, just like a Article 9 lien, reach out to third parties that owe the judgment debtor money. So in this case, if you got, as a supplier, a confession of judgment, you get a judgment against the sub, then you can go after the GC and say, hey, I got a judgment against this guy, pay me the money that you owe to him. He goes, I don't know him like $30,000. It's fine. I want that. Now, he may not give that to you, but once you do that, you're first in line for that amount of money, as long as your judgment is around for 90 days or more, which typically would be. Then so we didn't talk about the most basic collection, because it's something in construction that I find to be important and is essential. It's that you have a contract with somebody. So you can always sue somebody without a lien by breach of contract. I find, though, usually you're suing your customer or somebody that's owed money in the other job. So my focus here today has not been on the basic, hi, I'm collecting money against your customer alone, even though we do that quite a bit. And we generally are successful in working it out, or we have to sue people. But what happens is we create a situation where we have basically a ability to look at the customer and kind of work with him and at least get the facts from him. If he got paid, he's your main target if you don't have a lien, but there's other things which we've talked about, and we'll see what happened in our situation in Afghanistan in a minute. But what really is happening is you're able then to go beyond that. So a lot of our time is console is looking at the big picture, figuring out where the money's getting tied up and how you can get it paid to you as quickly as possible. And what we do, and you'll see this is what's happening in our situation in Afghanistan. I've talked to you a little bit about joint checks. I mentioned to you that word promissory estoppel, where somebody said to you, I'm going to pay you if you keep working, and I'm going to pay you by joint check. Now, it doesn't have to be by joint check. If they promise you in an equitable remedy, that's a representation by equity, that you should go ahead and work, and you're not going to do the work, which, of course, unless you get paid, and you told them that, and they said, yes, I understand, but I want you to go to work because this guy is not doing the work, and I need you to help him out, to help me out, okay? And that's called an equitable remedy, or in the legal term is called promissory estoppel. Now, sometimes, as I mentioned before, your role, a supplier to supplier in the bottom, you have no lien rights, and you're not in privity with the owner or the subcontractors. So some people, parties in privity with each other, can sue each other for contract. Equitable remedies that we're talking about is when you sue people that you're not in contract with. So how does a supplier, or in this case, a subcontractor working with a GC, sue the United States government, the owner, on there? Or in our situations recently, we were able to sue, even though we didn't have a contract with him, we were able to sue the owner of the company because he violated the trust funds. We didn't have a contract with him. We didn't have a lien with him, but he had an obligation, and we were able to get paid. And by the way, when we sued him, it was interesting because he defended the lawsuit by giving it to his insurance company, and they got tired of defending, and they were happy to make the payment. So it's interesting where you're getting your money when you don't have a lien sometimes, and who it's coming from. So what we're looking at is console, and what you need to think about when you create your facts, because your facts that you create for every project help you identify the remedy that gets you paid, is getting back to our situation in Afghanistan, is we said to the government, look, basically, we told you on December 31st, 2013, we said, you received a letter from the general contractor, and you told him 10 days before, he had to tell you why he wasn't paying. He said he wasn't paying because he was insolvent and ran out of money. He said he owed the subcontractor money, and even that was the case. You owed him money for extras. You put him in a bad position, but he did not use the money in trust or like he was supposed to and pay the money that he received on the draw application for his subcontractor, which was my client. He wasn't my client then. So these are the facts that were created. And one of the things I want you to leave here with is that every day, the decisions you make and the facts you create in your credit and your legal compliance program is going to make a difference as to whether or not you're going to be able to pay quicker and how long it's going to take you to get paid. I mean, for the most part, from the historical record of the thousands of project collections we've had over 40 years, each one, I try to remember them all. My memory is better than what my wife and kids remind me every day. They think I'm not remembering things, or I'm not, able to, recall the facts as they would like them to be. But I remember them pretty well. And we've had thousands of projects and thousands of clients, probably have hundreds of thousands of projects that have literally gone ahead through what we've worked on and what our notice services work on and our lawyers work on in every state every day. And in doing that, all of our clients like you and all the people like yourselves and your lawyers that you work with and people locally, they help you and you create the result that you hopefully intend, which is getting paid. And in doing that, this situation, our client went ahead and was told that this general contractor was broke. It wasn't a secret. Everybody knew about it. The contract officer, the contract officer representatives, everybody. The Department of Accounting knew about it. So they created a situation where they created a new payment mechanism that I've never heard of before, but it was something that was very protective of our client. And in a situation here, what's occurred is that in a general sense, because we're not going to be getting into very specifics, it's a very generalized discussion of what's part of the public court opinion, is what I'm showing you and discussing, is that the client told the general contractor and the government one simple fact. He was not going back to work, and he was not going to go back to work if they expected him to be paid by a general contractor that continually had not paid him. So what did they do? They opened up what's called a special account or a third-party account and put money into basically an account and paid him directly from that. Or, as he said, he wasn't returning to work. Now, what does that create if somebody goes back to work for somebody else paying them? That's called an implied in fact contract. They're difficult to prove. And that's why your facts that you have to create, and we had nothing to do with the facts. These are all facts that were created before we were involved. In fact, I wanted to tell you this because I'm hoping what the things that happened to our client at that time was something that you're going to remember when you find yourself, if you ever do, in this situation. So when a court looks at all the circumstances, our goal is to show a meeting of mind exists between the parties, even if the agreement was never formalized in writing. So to establish an implied in fact contract, for example, a person must demonstrate the same elements for an express contract. You must prove the mutuality of intent, consideration, an unambiguous offer and acceptance, and the actual authority on part of the representative, in this case the government representative, to bind the contract by objective evidence in order to show the mutuality of intent necessary to form the formation of an implied in fact contract. Well, I would call that common sense, but common sense doesn't get you paid. And I can say to you that courts have a very detailed examination of what they did. So we'll talk in a minute a little bit more about what happened. But we are seeing today, all of us, in unique times, legal disputes are increasing. Payment issues, performance issues, extras, delays, modifications, scheduling, defect claims, negligence, liability for design, build projects, breach of warranty, and termination. These are all risks that you see every day that are out there that you have to deal with. So how do we deal with these disputes? I mentioned before that depends on your contract. Mediation could be added to your contract, but it could either be binding or non-binding arbitration. You could join third parties or not. You could bring in certain law provisions. You can choose venue provisions, a jury trial versus a judge trial. All these are your opportunities to choose. And you've got to decide what works for you. Now, when you're having these decisions and when you're talking to your customer, teaming and shared risk is becoming something that I see more and more is a strategic partnership between a supplier and a customer. So these are kind of conversations you should be having with your customer before you have problems and say, look, if we run into problems, I'd like to do this. And he or she will say, I would like to do that. And you go back and forth and talk about how is the risk going to be allocated and how do you look for ways to lessen the cost of legal disputes and how do you team together and build good relationships. That's really something that I think is important as a discussion for sure before you sell, and it's also a discussion if you find yourself into a problem. So is your customer going to be bonded? That tells you something about his capability. That gives you a reason not to have to lien the job because you have the benefit of a surety bond. And under law, particularly public projects, they're required. Payment and performance bonds are required. What are the other remedies that you could look at? Well, breach of contract, which is a collection remedy, is one. And that's something that you always have based on the contract. Most of what I've spent time on isn't talking about how to sue somebody on a contract, because usually the person we're attempting to collect money from on a contract, if they have the money, they would have paid it. If they don't have the money, you have to understand the reason why. And that's kind of why, we haven't focused on breach of contract, but we have talked about if your contract has the right clauses in there, it'll protect you, such as a Article 9 granting of a security interest on the proceeds of your customer's rights to go against his customer. And we've talked about a confession of judgment, which I think could help you if you put that clause in. We see that a lot with suppliers and subcontractors, confession of judgment language. Then we just talked about bonds, which are payment bonds. And then there's discharge of lien bonds. If you lien a job, somebody discharges it, then you have to go after the bonding company and so on. We haven't talked about unjust enrichment. We haven't talked too much about third-party beneficiary. We will. We did talk about joint check agreements. We did talk about state trust fund laws. We didn't talk about the prompt payment laws, but the laws require you to be paid promptly. In Illinois recently, we just filed this week a summary judgment case against basically an owner who didn't pay our client, who was hired by a real estate manager to do some work on a medical building. In that particular case, we found law in Illinois, which was very favorable. And that law said, if you're the owner and the general gives you a payment application and you don't object to that payment application within 25 days, you're bound by it. And if you do object, it has to be in writing. So the manager said, well, you're charging too much money like a year and a half later. We said that's ridiculous. So we found this law as a prompt payment law, and it starts out with, if a general doesn't get paid by an owner within 30 days, and the owner did not object to the payment application, which is nothing more than submitting an invoice or request for payment by the definition of the statute, then the owner is bound to pay him the amount which he was billed. In the other situations, you'll see that GCs have to pay within 7 to 15 days, typically, money that the owner pays them to the subs, and the subs have to pay, in many state laws, to the suppliers. Then there are retainage laws that are there to protect you. And then there's also potential liability, which is what we're talking about in our story here, with third parties. Sometimes a construction lender can be sued, many times an owner, and even though you don't have preview of contract with somebody, they conduct themselves in a certain kinds of way to create liability. And that's where we come in with the claims such as implied contract of law or third-party beneficiary or promissory estoppel. So there are ways for you to go ahead and obtain payment, even though you don't have a contract with that particular person. And we've named them before. The example I gave you with the carrier in Colorado, where we sued the Georgia contractor that filed an assignment for benefit of creditors and sued his president personally for violating the trust fund laws. We got paid. Then we have a situation where in another carrier case, in a Colorado electrical contractor, the customer that did not get paid by the general contractor and the owner, and we were able to sue them because the customer that we represented, the sub, had its client who was the general contractor, and the general contractor went out of business and the carrier didn't pay. But the carrier said to our client, hey, I know you're owed a lot of money. We want you to continue working and finish these jobs. And so the large carrier finally ended up settling with us after the general contractor went bankrupt. We had to go to court. They threatened to throw me personally in jail in that case. They said, you're violating the automatic stay by going after the owner, and that money belongs to us, the trustee. I go, no. The owner promised our client, the sub, to continue working. And when they promised him to continue working, we said that we would be in a position to get paid by you. You gave us the impression we were going to get paid. You didn't stop us. You held money back from the general contractor, and now we want to get paid. And finally were able to settle with that, and we had to give the trustee $50,000 on a couple $1 million claim just to make him happy and go away. So sometimes you have to be practical when you're talking about settlement. That's why 97% of the cases settle. Now, one of the key things here is when you identify the remedies that gets you paid. I want to get back to our case in Afghanistan. There's a written opinion where the court said in it, both parties acknowledge that the court must contemplate similar facts when considering the subcontractor's third-party beneficiary and implied in fact contract claim. But he pointed to the provision of the complaint that we talked about and the documents that we provided as evidence. These are the facts that were created. Docket 15 and 21. These are documents that were created by our client. And the judge said, with regard to the third-party beneficiary claim, our client raised a non-frivolous claim, which means a good faith claim, that the contracting officer intended to enter into the contract. The government then asserted that our subcontractor's claim for a breach of implied in fact contract, the government wanted to dismiss it because they said we cannot show the mutuality of intent. And we cannot show that there's an unambiguous offer and acceptance or an exercise of actual authority on the part of the contract officer. In contrast, we, the subcontractor, claim that the contract officer put a memorandum out that we found approving the creation of the holding account, specifying how the funds were to be distributed, then that created an implied effect contract. And the government said that we said that the government manifested intent to accept the offer to return to work. So far the judge is we haven't told you how the judge ruled on the government's motion to dismiss, but it's very hard to prove these cases. But if you can create the facts as you go through your transaction, and even if there's a bankruptcy, then in those situations, you can get through the bankruptcy and have an independent right against not your customer that's bankrupt, like in this case, the GC, but against the owner. So what the judge finally said in the very early stage of this case was that we pointed to objective evidence to support our claims. And we had extensive written communications who assured them the government was going to take steps to ensure we were paid, and that these communications were authorized by the contract officer and provided the court with emails to corroborate all this. And while the government disputes this allegation that the owner was going to pay our client, they could not refute it. And without sworn statements, which they didn't have at the time, then they cannot deny that the contract officer intended to benefit our client, and therefore the court must take the allegations supported by some evidence as being true. So that's been a case that we're in the process of enforcing in federal court right now in Washington. And the COVID pandemic has, delayed some action in a lot of cases today. We're all seeing that, but it's now proceeding, and we're going to look at facts that the client created at the time of the transaction, and those facts will make a difference as to what the outcome of the case will be. So your facts that you create by how you extend your lien credit or your credit to your customer, and how you track the facts and what other relationships you engage yourself in at the time will then help you later on get paid. And even if you don't have a promissory estoppel, a third-party claim against somebody else, you hopefully will bring dialogue up between yourself and your customer, and then you may need to engage counsel to try to reach out to other parties. But we find that talking to people, particularly these days, people are looking to resolve problems, and in doing that is very helpful. And you have to understand that you have rights, and they're based on your on your contract, your statute, and on what's called the law of equity. So National Lien and Bond Claim Systems, our legal network, we developed originally when we first organized the network with all the lawyers, a really great formula to negotiate payment that'll help you. And what we came up with is for you to have your credit and your legal power, you need to develop a transaction, which is your contract, plus your power, and that equals your payment. So we've kind of like looked at this from 1986 till today. How are the contract rights, or how is your transaction formed? how did you do your internal compliance, which is your credit and legal work, and what are facts that you created, and how can you represent your transaction to protect your rights is really the power behind every decision you make when you're working with your customer. So you're enforcing the elements of your contract, of the statute, and the equitable remedies. How we recommend you do that is obtain a project data sheet. We have a form that's filled out, and we help calculate your steps and deadlines for every project. We help you verify the source of funds up front, find out whether the jobs are bonded or not, and minimize in your contract to have risks with favorable terms to help you and a rider address the legal risk. And we have copies of that rider available. You'll be invited to obtain that through our follow-up that you'll get. Now, the biggest problem people have is the cost of collection. And sometimes it's recoverable under statute for liens or prompt payment laws or trust fund laws. Many times it's not. We felt, we'll tell you about a program. Our network of construction providers and notice providers really actually we've lived together and have a passion to enforce your lien rights and your legal rights on a job-by-job basis. And we pursue justice for our clients, and we offer these services through a network of notice providers. And again, as I mentioned, many of you may know a local notice provider or a lawyer in your jurisdiction that you like, and we certainly like to know about them. It'd be very important. These are the projects that our particular office has been paid out to date for our clients, the average claim amount. And what we're finding is basically that our co-counsel, our notice providers, do about 20 times more. So we've literally had close to $100 billion of collections as a group. And I'm very proud of the fact that we're teaming together throughout the United States with excellent lawyers. I mentioned our lawyer in Colorado that had a Supreme Court case of Colorado that basically if you don't do exactly what you're supposed to do in Colorado, you're going to be in big trouble. And I'm proud to say he's typical of the lawyers around the country that we work with. Every one of them have a story almost just like that. And most of them have Supreme Court or appellate court decisions that stand behind that. That's how I get to be so smart. I have surround myself. I have a very good talent with smart people, much smarter than me. But I'm a good manager and a networker, and it's so great to have the chance to meet everybody. I wanted to also announce to you, we're exploring a new program right now. And I wanted to show this to you. And that is a program which you'll get some information about, where we don't want you to spend good money after bad, but we want you to see that we're able to provide for you a situation where we're going to get a program that we think will be very successful. We think it'll be a new way. We think we changed the way law was practiced a little bit in 1986 by teaming up with lawyers around the country to solve problems for clients when we need to, which is almost every day. And our success has been built on the relationships, the business sense, and the legal know-how. So now we're looking to try to create, if we can, and we're looking to do this where here's step one. When you file a lien and enforce claims, it's a smaller amount of money than when you're going ahead and taking the next step, which is collection. And then if you file suit, just filing a suit shouldn't be costing an arm and a leg. You can do it hourly or flat fee, but if you decide to do it on a contingency schedule, this is about the range. And then if you have to force the suit beyond that, then the costs are there. But we're looking and talking to clients about including step 1 and 2 together, and maybe some of step 3 we haven't decided, with no upfront cost pre-litigation. And I think it's a really good value of what we're doing. And particularly since we've been successful, we're hoping that this new pandemic and the problems that we're dealing with aren't going to turn into a problem for everybody, but we think you got to be protected. So we want you to turn your legal rights into prompt payment. That's basically the theme of our story. So we've been doing this since 1986. I'm interested in understanding if anybody has any questions. And Irene wants to know, are we able to access and review this webinar again? Yes, Irene, we're happy to do that. I think it's been recorded, and I'll leave that up to our technical people to make sure that information will be provided to you. And I want to thank everybody for attending. If you have any further questions, you can feel free to reach out to us, and we'll certainly reach out to you with our new program. And I'm looking forward to making sure that every day you are in a better situation, and that I hope that this program has been helping you provide yourself into an understanding that when you're selling in the construction industry, you're effectually providing multiple credit extensions, whether you know it or not. And it didn't take me long to know it, because many times I found that our customer wanted to preserve its relationship with its customer, our client, so we had to work together and together get paid. So what NLB has done is not only team together really good legal talent around the country and notice services, but we want to also have you, when you have a problem, look with your other subs and suppliers to team together in solution. So we've been involved recently in the last 5 or 10 years doing unusually teaming together. We have a situation right now where we have about 26 telecom technicians who we're working with together, and we were able to come up with a very affordable fee for everybody. Again, I don't know why, but the telecom business has been keeping us busy. The subcontracting installations and business of all kinds of materials and equipment have been keeping us busy. The bonding company is not paying on time. They've been keeping us busy. So we want to be able to be in a situation to help you obtain the resources you need. And we also would love to hear from you about any other legal counsel, or if you have any questions that you need help on, we certainly will be there. So thank you very much. I don't think there's any more questions today. So I'm going to end the meeting, and please look forward to getting some information from us. And thank you so much for attending. We do this because we have a passion to see that our clients, like people like you, get paid and get treated fairly. All right. Have a nice day, everybody, and stay safe.